afternoon. My name is Elizabeth Anderson, and I'm the Executive Director here at the American Society of International Law. And it's really a treat to have you all here for a very special briefing behind the scenes at the World Court from Professor Pierre d'Argens. Our event today is going to be recorded, video recorded, and posted later to our website, so those who can't be with us can be a part of the conversation. I ask, therefore, that when we get to the discussion, please wait for a microphone so that your question can be heard on the recording and benefit those who view this event after the fact. It seems sometimes here at the Society, our events seem to, just by coincidence, coalesce around a particular topic. So sometimes, just by coincidence, it seems like it's International Environmental Law Week at Tiller House, or it's Trade Law Week at Tiller House. I would say that this is ICJ Week at Tiller House, or at the Society. Several of us are leaving this afternoon to travel out to the West Coast, where we will be hosting a series of talks, and lectures, and meetings for ICJ Judge Joan Donoghue. As she wraps up the first year at the court, she's going to be giving these lectures reflecting on her time there. And that too, some of those events will be posted to our website. I believe that the event on Monday evening at the World Affairs Council of San Francisco will be live webcast, so you can continue in this on this topic then. But today, while Judge Donoghue may be presenting the front side of the court, today we're going to hear about the back side of the court from somebody who's really well positioned to tell us about it, and that's Professor d'Argens, who is currently, of course, at the law faculty at the University of Louvain. He was, though, until earlier this year, first secretary at the International Court of Justice in The Hague, and had a first-hand view of how things go behind the scenes. He's, before that, held a number of positions, academic positions at different institutions, has a long list of prizes and fellowships and recognition of his expertise that I think at least an excerpt of which is on your seat, so I won't elaborate. We'll instead turn directly to Professor d'Argens to tell us how it goes behind the scenes.
Thank you very much, Betsy. Thank you for those kind words. And I should indeed say a few words of gratitude, ladies and gentlemen, to the American Society for having so quickly put up this event. Professor Karen, who is absent, but with whom I corresponded. To you, Betsy, and to the Tiller House staff also for setting up the event. Also, thank you very much for your presence, and I look forward to your questions. Now, a few words of explanations about the title that probably arose your curiosity. Behind the scenes, as you mentioned. This is your title, actually.
I'm the PR person here.
Yeah, a very good title. Behind the scenes. Yes, I'm going to embark on in a certain way, an exercise about a certain demystification of the ICJ. I'm not going to tell you any secrets, but I'm going to embark on some form of transparency exercise, and I think it is, for the sake of the institution itself, I think that a better understanding of the way it works, I hope, will help you to better understand what it produces, the results that the court can come up with, and maybe it will help you to reconsider some misgivings that you may have about the ICJ, and to consider really what added value the court can give in solving disputes. I'm actually not going to tell any secrets, because I'm going to comment a text which is public, which is the resolution concerning the internal judicial practice of the court. I'm simply going to put that document into context and to give you some concrete perspective on that document. Now, the second also explanation, not only about the title but about the subtitle, the explanation that came up on the website on this issue of the digestion by the court of thousands of pages. Well, yes, we lawyers are really used to moving around a lot of papers, and the court moves around a lot of paper, and the parties submit to the court thousands and thousands of pages. How do you, to take a few examples, how do you digest the 14,521 pages of the Argentine-Uruguay case, and how do you transform those 14,000 pages into a judgment of 80 pages? As I see Sean Murphy in the room, how do you transform the thousands of pages submitted by, I think, 43 submissions, 43 states?
In Kosovo.
In Kosovo opinion, 35 in written form, and 28 in oral presentations, and some of them in both, of course. How do you come up with an opinion of about 45 pages when so many pages have been submitted to the court? And I take those two examples because they are very different from each other. One is highly scientific and technical, the other one is highly political. Nevertheless, despite their differences, they are submitted, or they are digested in a similar way by the court. So in order to try to answer that question, let me make first a few general remarks and then come to the briefing and some concluding words at the very end. My general remarks are on the relationship or the role of the court regarding the dispute. ICJ proceedings, I think, are transformative of the dispute between the parties in several ways. I'm not going to talk about the virtue of ICJ proceedings as an horizon during diplomatic conversations between states. It may help states to settle their dispute more easily if they know that at some point one of them can bring the case to the court. That I don't know, I'm not going to deal with that, but this is of course something to be kept in mind. What I want to say about the transformative nature of the ICJ proceedings is first and foremost, and this is very obvious to any lawyer, you change language. You stop or you depart from a purely diplomatic or political language and you start framing your arguments in legal terms, and you hire professional people whose job is to speak the language of the law. Of course, you don't completely depart from politics, but there's already there a transformative effect of the ICJ proceedings because you change language, you turn to a rationalization, a language which helps to rationalize the dispute. And you do that in light of within a setting, within proceedings at the ICJ that are public proceedings compared to arbitration proceedings. On the very day of a request, when it's filed with the court, every UN member state is informed. Every member state can ask to see the documents. Every member state can intervene. International organizations under the auspices of which an instrument which is discussed or in debate for the case may submit its own views on the interpretation of the instrument. So the setting, the dispute, it takes a certain public form because the proceedings of the ICJ are what they are, and because of that publicity given to the dispute, I think states, of course, are very careful of the language they use. So there is already this transformation from the simple fact of turning to the language of legal argumentation. And then also all the proceedings, and that is very clear, I think, when you look at the proceedings of the court. The proceedings are designed in order to shrink the dispute. It's a kind of bottleneck plus a filter, if you want. The dispute, the virtue of the proceedings is to limit the dispute as much as possible and to really help the states come down with very limited and specific points in dispute. And this shrinking effect comes first, and you know that very well, from the fact that the jurisdiction of the court is not compulsory. Hence you have to find a basis for jurisdiction, and the subject matter of the dispute must come within the jurisdiction of the court, ratione personae, materie, loci, and temporis. And that, of course, has a shrinking effect of the dispute. And sometimes the dispute submitted to the court, you know, is just the tip of the iceberg of a very larger, bigger dispute. Take the Bosnia case, for instance, take the Georgia-Russia case, of course. The court is one card that states play in that larger political dispute, but the dispute submitted to the court helps shrinking down the dispute between states. Also, the court only has to answer the final submissions of the parties, and not, and that can evolve throughout the proceedings. If you compare the request to what states state in their written submissions to what they say in their final submissions, you have an evolution. You have not new claims. I mean, you cannot submit totally new claims unrelated to the object of the dispute, of course. But claims are dropped, arguments that were made changed are not raised anymore, and the court only has to answer what states request at the very end of the proceedings in the final submissions. I remember very well as counsel to the DRC in the warrant arrest case, as you know, there were actually two issues, an issue of immunity for the Foreign Affairs Minister of the DRC, and an issue of on universal jurisdiction and the exercise of universal jurisdiction in absentia. Well, the two issues were logically linked to each other. You cannot answer a question of immunity before knowing if the courts that are dealing with the case have jurisdiction. And in the written submissions, the DRC asked the court to give a judgment on the issue of universal jurisdiction. Now, knowing how things were developing, knowing that the universal jurisdiction in absentia was a difficult issue, that it would be divisive for the court probably to deal with, that the DRC wanted a quick judgment of the court, it turned out that the only real claim made by the DRC at the end of the submissions was the issue of the immunity. And in many cases you can see the dispute evolving throughout and thanks to the proceedings. Also, you will notice, if you read carefully the judgment of the court, that the proceedings, talking about digestion, I'm sorry during lunchtime to carry on talking about digestion, but the proceedings are there first for the parties to digest by themselves the dispute, and then it will be for the court to digest what remains of the dispute. But the proceedings help the parties to, on some point, not on all points of course, but to come to terms with each other and to try to agree. And if you read carefully the judgment of the court loves to point out that on that issue, the parties don't disagree anymore. And actually the dream for the court, the fantasy for the court, is that the simple fact of coming before it would make the dispute evaporate by the simple fact of appearing. But it's very clear from the reading of the judgment that the court does not have to and will not deal with any argument when the argument is dropped or the argument is not contentious anymore. And the court loves to point that out. And this brings me to my second general remark. The business of the court is to settle dispute. And in order to settle dispute, the court first decides and then gives reasons. In that order, I think, as any judge actually. It makes up his mind and then it gives reasons for the decision. Now, those reasons turn out to be, in a way, minimal for the time being. The court works according to the principle of judicial economy. You give the minimal reasons that are necessary to explain your decision, but you don't say too much. Why does the court behave like that? Some people will consider that because of the change in the composition of the court over the last 30 years, you had a court which was made much more of academic people or people with an academic background. Now you have a court which is made up of former officials and professors, and maybe that change in the composition of the court explains that people don't like to talk too much. I don't know if that's true. Maybe you can say that it's because the docket of the court is very busy and that the judges have too much to do, so they tend to reduce things to the minimum. I don't know. I mean, those can be used as explanations. I think there are more profound reasons for the judicial economy used by the court. First, I think it's in the nature of any judicial body to try to avoid to prejudge the next case. And the court doesn't know what will be the next case, and that can explain, of course, why it says as little as possible when it settles a dispute. And secondly, I think there are specific institutional reasons to the ICJ. It's not a compulsory judge, and then institutionally it is in a way fighting for its own survival. It doesn't want to put up future clients. And secondly, the authority of the rulings of the court depend very much, I think, on the majority or close to unanimity ruling that it can come out with. And a way to avoid public dissent within the court, as judges may write dissenting opinions, is to just not to elaborate too much on the reasoning, because they might have different views on that or that explanation or sentence, and in order to avoid having a judge voting against simply because the court takes a stance on an issue of principle that is not absolutely necessary, then you will find out that some part of the reasoning is limited or to what you just need. So keeping that in mind, those two general remarks, I turn now to the substance of this talk, which is this briefing on the internal procedures of the court. L'affaire est en l'état. The case has been pleaded in written form and in oral pleadings. It's taken under the deliberation of the court. What happens? In order to know what happens, just a quick look at the forces at hand. Who works with and for the 15 judges? You've got about 100 people within the registry of the court. You've got a legal department of 8 people, a linguistic department. I'm going to elaborate a little bit on linguistic issues later on, but it's a very time-consuming question within the internal work of the court. You have a large linguistic department, about 15-20 people. You have an information department, typing pool, etc., reproduction archives. You even have a doctor for the UN civil servants. And you have recently the addition for each judge of a clerk. Each judge has now a P2 clerk. Previously there were only university trainees that were sent by some universities, and then under the presidency of Rosalind Higgins, the General Assembly gave enough money to get one P2 for every 2 judges, and now the General Assembly gave enough money for the court to hire a P2 for each judge. This might sound normal, and it's certainly very welcome, but it really has changed or is changing the culture of the place, because the judges have their own assistant and hence do not rely as much as they do before for research purposes on the work of the registry, which is headed by the registrar. So I'm not going to dwell on the relationship between the P2 and the judges. The judges are free to ask their clerk to do whatever research they need. There is not much coordination between the clerks of the judges and the legal department of the registry. There's no need to be a high degree of coordination, but I'll come into that when I'm going to talk about drafting committees. Now, the legal department of the court produces for the judges, for the full court, before the case is under deliberation, the summary of the proceedings, that is the qualité, the very beginning of the judgments, in which actually you can see the evolution, all the procedural history of the case. This might sound very boring. It is actually quite boring to draft, but it is very important to see the evolution of the case. The legal department produces also, and the judges may ask their clerk to add or to do that in advance or to elaborate, produce a summary of arguments of the parties that will help during the drafting of the judgment as the parties' arguments are summarized before the reasoning of the court on each point, as you know. And that already gives, of course, a kind of structure for a future judgment. And sometimes it's easy to do, sometimes not, because parties, you have different strategies of different parties. Maybe the defendant would like to stick to the order of arguments presented by the claimant, maybe not. And so you have to put all that together. And then quite an important document submitted to the court is called the list of issues. The list of issues is the document which is envisaged by Article 3 of the resolution concerning the internal judicial practice of the court, and actually it's a list of questions. It's a list of questions. All those documents are confidential and are for the judges. It's a list of questions articulating the various questions in a logical order, with eventually, if you answer that question in that way, then this other question is raised, and if you answer that question in another way, then you should look at this other question. Only questions, references to the pleadings, written and oral, no answers, of course. It's up to the judges to make up their mind. The judge also receive from the library bibliography on the case, chronological list of documents, etc. I'm not going to go in those details. But the main document, I think, is the list of issues that has to be understood and read together with the summary of arguments. Now, what is the procedure when for judgments and advisory opinions? I'm going later to give you a hint on what's going on when you have only orders. The general proceeding. The end of the hearings is what is called Article 3 deliberation. After the second round of hearings, there's a short deliberation within the court, and the court looks at the list of issues. The list of issues has been distributed to the judges between the first and the second round of oral arguments, and the judge amend, change, drop some questions, because again some questions at the very end of the second round seem to be of no importance anymore because the dispute has changed. But the judges are called to adopt the list of issues collectively, a final draft of the list of issues. After that, it's a very short deliberation, it doesn't take long. After that, the judges individually go in their room and they write their note. So each judge is called to write a note, which is the presentation by each judge of his own views, his or her views, on the questions. And the judges may follow the list of issues. They are not obliged to do so. They are not obliged to answer all the questions raised by the list of issues, but the list of issues is a kind of common frame for the judges to write their notes and help a kind of comparison between the notes of the judges. The judges write their notes. They have, depending on the importance of the case, a few weeks to write their notes. Those notes have to be translated and then distributed among the members of the court. Usually the judges meet their deadline, of course, but if they don't receive the notes of their colleagues as long as they haven't submitted their own notes, in order not to be influenced by the views of their colleagues. After the notes have been written by the judges, and those notes can be 15 pages long or 80 pages long, 100 pages long, depending on the case, depending on the judge. All those notes are translated, and then the court meets for the big substantive deliberation, which is Article 5 deliberation, again Article 5 because of this resolution. It is the main deliberation. It is during that deliberation that the court actually, the majority of the court is formed on the main issues. And each judge is called upon in inverse seniority order to present its view. And the Article 5 deliberation can go on for 3 days, 5 days, 2 weeks, 3 weeks. You have 15 judges plus 2 adults sometimes, and it takes time to accommodate all those people talking, and they like to talk. Of course, they are lawyers. They interrupt each other and they disagree with each other, and it's a deliberation. It's a negotiation, if you want. Some people remain silent for a while and then come out with ideas. Some people speak a lot. So it really is a collective moment for the court. At the end of the Article 5 deliberation, the President summarizes up the debates, and you then can see fairly clearly where the majority of the court stands on the main issues. And then the drafting committee is elected by secret ballot. Well, the President has taken contact with his colleagues, and it's a secret ballot, but it's not very secret in the sense that you know very well who's going to be on the drafting committee, who is willing to be on the drafting committee. And the drafting committee is composed usually of the President or the Vice President if the President is not of the majority, and 2 judges. Sometimes 3, but mostly 2 judges that are with the presiding judge, part of the majority of the court. And the drafting committee will be held by some registry staff. The drafting committee meets, short meeting on the division, the allocation of work between the judges, and then an individual relationship between the judge and the registry people and the clerk of the judge concerned, and then 2 or 3 meetings in order to compile together and to read together the draft with which each judge has come to. This draft is then compiled, translated and submitted to the court, and it's called a preliminary draft judgment. It's a preliminary draft judgment circulated among the members of the court in French and English, and the court does not meet on that preliminary draft. The judges receive it, and they have a few weeks to write written amendments, formal amendments, substantive amendments, and after the deadline for submitting the written amendments, the drafting committee meets and considers the amendments. Take some amendments, reject the amendments. No need for long explanations. It will be eventually for the President to explain why such amendment was incorporated or not. The amendments or the changes are made in bold italics so that all the judges may see physically where the changes have occurred. And the drafting committee submits a draft for first reading. And the court meets, and the first reading session is a reading of the draft. In English and French, each paragraph is read out to the full court, and after each paragraph, each judge may make some remarks on the draft. And you have not really a second deliberation taking place, but you have a deliberation on the draft. Everybody knows where the majority stands. Sometimes it's quite too late to completely change the result. Of course, it's not the purpose of the first reading. The purpose of the first reading is to come out with a better text. At the end of that first reading, and as each paragraph, except the procedural history, is read out, each paragraph is read out, you can imagine that it can take some time. And as each judge may speak after each paragraph, it does take a long time. If you take a short judgment, it can go fairly fast. But short judgments are sometimes very controversial. If you take a very long judgment, take the Bosniak case, read out the Bosniak case in French and English, it takes by itself a few days. At the end of the first reading, the judges are called to say whether they will submit a declaration or an opinion at the appended to the judgment of the court, and they have a deadline to submit, of course, their draft, the declaration or opinion. And when that deadline after that deadline, the drafting committee meets in order to incorporate the changes that were agreed during the first reading, but also in order to consider the draft declarations and opinions. And then you have, of course, a play between the judges and the drafting committee, because a way to accommodate, it's a last moment for the drafting committee to try to accommodate some judges, to try to reduce this public dissent that can occur, to try eventually to cut the grass under the feet of a judge that had the intention of publicly declaring that he found that this paragraph is outrageous and should not be agreed upon. And you can just take out the paragraph then, and the opinion becomes irrelevant. So there is, that's why I said at the beginning that there is this idea of trying to come out with the largest majority, or the least public dissent is very much in the genes of the court. There you can find it at play. The drafting committee meets, issues a draft for second reading, and again, bold italics are used to show where the changes have occurred. And you have the second reading. Now, we don't read again throughout the whole text, French and English. Only the paragraphs that have changed are read out. And again, a conversation occurs between the judges on those various paragraphs. At the very end of the second reading, you have the vote. Each judge is called to vote on each subparagraph of the operative part. And when the vote takes place, after the vote for the judges, that's it. Res judicata, the judges cannot say anything anymore about the case. They go back and read and write their opinion or their declaration if they intend to do so. But that's it for the court as a collective body. It's up to the registry to finalize the draft, to incorporate the last changes that were agreed during the second reading under the supervision of the president. It's up for the president to sign the registry, the judges to sign their opinion, etc. The official copies of the judgment for the parties and the archives, the information department writes the emails that you receive. Summary of the judgment is prepared, the text for the public reading is prepared, and letters are written to the parties and to the Secretary General of the UN, etc. And then you come out in public with the reading. So you have quite a long procedure that, at least I think, needs 5 to 6 months at best. It's that long. No, of course it cannot be that long for orders, and specifically for order on provisional measures. And as far as orders of the court are concerned, provisional measures, counterclaims, interventions, and all the purely procedural orders, you have a procedure which is much simplified in the sense that you don't have any list of issues, you don't have a summary of arguments of the parties, you don't have notes of the judges, you have one deliberation, the judge they meet once. There's no drafting committee, it's the registry who drafts according to what was said during the deliberation and where the majority lies. It's the registry which drafts a draft order. It is circulated, it is of course approved by the president and circulated after the president has agreed. And then you have one reading and one session of a first and only first reading and a vote. So for the orders of the court, you come up with a procedure which is much simplified. So this is very technical and a bit boring. This is extremely bureaucratic. But those are the various stages through which the dispute goes and is considered by the court, and how the court digests, as I said, the dispute submitted by the parties. Just a quick word on the issue of the translation. Translation might seem something of an old age, French and English. Why on hell do you need those two languages? First, it's in the statute, simply, and I think it does help the court to come up with a better draft when you have so many pairs of eyes that have to be sure that the two versions are the same, and it helps you to draft actually in your own language, knowing that it will be translated. So it is time-consuming, very much so, but I think it does help the court to come out with probably better drafts. The procedure is, of course, very lengthy, and as you noticed, I took the internal procedure after the hearings, and you might ask yourself the question, well, what happens before the hearings? Is there any way that the court is going to digest the case before the hearings? Well, no. The dispute is in the hands of the parties, and it's not really in the control of the court to, you know, you don't have a general advocate, you don't have a juge rapporteur, you don't have somebody officially on behalf of the court who is going to digest the case, it really is up to the final submissions that you really know what the dispute is about. And before that, the court probably has always considered since the 1920s, that it was not up to itself to intervene in the dispute and that's probably why the court is so reluctant to order expert opinions on technical matters or things like that. And I think this is really related to the perception that the court has of its role regarding what is the dispute and giving as much as possible the possibilities for the parties to manage their disputes themselves and not stepping in at a too early stage. Now, just a few words of conclusion on that briefing. I think one of the virtues of the procedure is its boring bureaucratic character. Rationality comes out of those various digestion stages. It's a long process in which many hands and eyes and brains are used. It's slow, but I guess in a way, in a Weberian way, if you want, this bureaucratic procedure is virtuous and is rational because it is bureaucratic. And it's a collective effort. No one really has the upper hand. The court is a collective body, 15 judges, all with one and only one vote, all with one and an equal vote. Those judges are helped by their clerk, by the staff of the registry. They rely on them to draft, and there's a constant conversation between many people involved in the drafting of judgments. And that is why probably, as there is more in two brains than in one brain, that's why let's hope the results is not always convincing, but rational at least. Yes, there should be more things to be said about this relationship between bureaucracy and rationality, but I'm going to stop here and take your questions. Thank you.
Well, thank you very much, Professor Darsham. I think I will open it up to, I've got some questions myself, but I'll open it up to what I'm sure will be an eager audience. Mike Matheson, maybe Nino, can I ask you to pass the microphone to our guests as they pose their questions?
Am I supposed to identify myself?
Please do.
Mike Matheson, George Washington Law School. Very interesting presentation. One of the common criticisms of the court is that it does not do a very good job with factual disputes. Particularly, for example, in the case of disputes about armed conflict, where you would expect that the judges would not necessarily have technical expertise to resolve some of the factual questions. And it can't be resolved simply by looking at documents. The court, of course, has various techniques within its authority to deal with such things, as it did in the Corfu Channel case: appoint experts, masters, conduct inquiries, whatever. You suggested that the court was reluctant to appoint experts because it didn't want to tell the parties how to proceed, and yet you would think that the court felt some responsibility for dealing on an accurate basis with factual issues, even if the parties had not completely resolved the issue. So why is the court so reluctant to use these tools at its disposal?
Shall I?
Why don't you answer
okay,
that.
Okay. As I said, I think one of the reasons is that the court lives with that fantasy that, of course, it's a fantasy, but it hopes that it doesn't want to interfere too much. It tries to leave the party managing the dispute by themselves. No, I think regarding, and that's probably why it doesn't like to appoint expert opinions. Also, the court is not, I mean, we don't have a list of experts, let's put it that way. There's no, like in domestic courts, it wouldn't be very difficult to compile such a list. But it's simply culturally not the habit of the court. And suddenly it should occur way before. And there's, as I said, there's no collective digestion by the court of the case before the end of the hearings. There's no one who can flash out a light saying, before hearing the parties, we should meet and order an expert opinion for it to be submitted to the parties, and then let's hear what the parties have to say about it. Because if there's an expert opinion, of course there must be a debate between the parties on the result of the expert opinion. And of course this could be changed. You can amend the rules of the court. But the very fact that the court never really felt the need to do so is probably related to the way it perceives its role regarding the parties. Now, on the issue of fact in armed conflicts, I think the question is not only related to the court itself, but I've always felt really uneasy with that issue, because actually the court is called to judge governmental decisions that were taken on the basis of documents that is simply ruled out by the court as being unilaterally established by one party. So it's, I think, quite strange to live in a system where a government takes a decision on the basis of, pictures, reports made up by state agencies, and let's take the oil platform case, for instance. Everything that was submitted by the US was seen by the court as being, could have been fabricated in a way. There is this suspicion that a document submitted by one party is a fabricated document and hence should not be taken really into consideration. And the unease comes, and of course you can, it's not the first time that a state would, even before a court, would, I'm not saying that it is what occurred, but I can understand that the court is very careful in taking into consideration documents unilaterally submitted established by one party. But then the real problem then goes to the law of state responsibility, in which error, factual mistake, is not an excuse in the law of state responsibility. And if you take the two together, if you have a court that says, well, I'm not going to take really into consideration the documents on which you base your decision, and actually maybe you took a wrongful decision, a bad decision, and at the same time you can't be excused for having taken that wrong decision on the basis of documents that I myself consider as being irrelevant. That creates a real unease, I think. But it's larger than simply the fact that the court is suspicious on the documents submitted by one party. But how could it not be suspicious? No?
All the more reason why it should seek outside advice to try and resolve.
Yeah, but on what? On what? If you ask, satellite pictures, who has satellites? You would end up writing a letter to a US government agency asking for pictures because they are in your hands. If the US is not party to the case, that would be easy. But if the US is, how can you be sure? It's only the court, It doesn't have any policeman to go and look in an office to make sure that what has been submitted is exhaustive and that nothing was left behind. So in a way, it really is a court in the hands of the states. For some.
Professor Crook.
Well, I must say I'm very uncomfortable with the discussion we've just had, because it means that very few states are ever going to be able to prove self-defense. And I think the set of essentially evidentiary principles that the court laid out in the Congo case make it impossible for a state in many situations to prove the legitimacy of its action. And I think there's a problem there.
Of course, I agree with you.
A different question, going back to really what happens before your discussion today, of the material you discussed today. Can you talk to us a little bit about advocacy before the court? Oral advocacy, written advocacy, what makes a difference, what works, what is helpful to the court?
Well, I think a judge would be in a better position to answer that question. I really think it depends on each judge. I think oral presentations remain crucial before the court. Of course, oral presentations are the only presentation on provisional measures, for instance. There's no real written exchange of arguments. The only exchange occurs orally, so it is of paramount importance. On the merits or on preliminary objections, I guess, it's extremely difficult to say how much judges invest themselves in advance ahead of the hearings and read through. I'm not sure that the 14,521 pages were read by each individual judge. I'm pretty sure it was not, and that's why they are held. And that's why also oral presentations are very important. And it might be, it's a tactical move that the party and counsels make if they submit so many. They know that if they submit so many documents to the court will have to rely on a kind of summary of those documents, which is prepared and presented during the oral presentation. So, it depends really on case to case, and it's probably really tactical moves by the parties when they write and they draft the written presentation. But the oral presentation remains really of paramount importance, I think. Many judges make up their opinions, I think, during the oral presentation. And it is during those oral presentations that you really see where discordance between the parties occurs.
Question over here?
Yes, thank you very much for your presentation. I have the impression from certain aspects that you mentioned, particularly the fact that the court is very careful in admitting certain evidence submitted by certain states, but also by the very interesting observation that you made that the procedure of the court is very administrative or even bureaucratic, and that it has been framed this way on purpose. I see there may be a tension with one of the objectives of the very International Court of Justice, which is the fact that they have to apply international law. Because if the court feels so constrained by so many different factors, and if the court even tries to establish a procedure in such a bureaucratic manner, isn't there a risk that the very objective of the court, which is determine on a certain manner, in a judicial manner, what is international law and what rules of international law are to be applied and come into play in a certain case, isn't there this risk of losing the path of this objective?
Thank you. And can you identify yourself?
Yes, I'm Björn R. from the University of Alcalá in Madrid. Spain.
I think the very purpose of the court is not to, of course, we academics like to see it that way, developing international law and etc. I think the purpose of the court is settling disputes, and in order to do so, using the rules of international law and articulating the reasons for the settlement that the court decides along the lines of the rules. So you know, I don't think that the procedure and the length of the procedure, the bureaucratic nature of the proceeding, of the internal proceedings, in any way distract the court from that objective of resolving the dispute. The very purpose of the court actually is, and that's why it's very difficult. I'm always reluctant to talk, as many of my colleagues in the academic world do, of the constitutional court, of the international legal order, etc. And I think this is way overdone, and it cannot be the case for such a non-compulsory court, and it's not really the way it understands itself. It's there to settle the dispute, to help the parties to turn the page and keep on living together afterwards, and giving some pronouncement on issues of principles when that is absolutely needed. But I don't think the court is at its best when it does great doctrinal work, to say things. No, I mean, you know, it's not there for that, and there's no one above it to you know. The judge knows the law, yes. Many times have people criticize the fact that the court was inventing law. It's not the best way to attract clients, to surprise them, either by coming with a result that is completely unexpected, or by inventing rules that are not absolutely necessary to declare in order to settle the dispute. So I'm maybe a bad academic in the sense that I praise the minimal approach, but I think it's quite virtuous actually. If you want to develop your case, though, that's probably having a certain profile is best.
Okay, Christina.
Also, thank you for
Here, wait for a minute for the microphone.
Christina Cerner with the Inter-American Commission on Human Rights. I'd also like to thank you for your presentation. I have a short, simple question and then a little more complex question. The simple question is, are the parties required to submit the documents in both French and English? You mentioned 14,000 pages.
No. They are not required to do so. They are required to submit documents in one of the languages of the court.
And
if they provide, and then the court translates.
Wow.
And the court translates. The court translates what we call volume 1. I mean, of all the written pleadings. That is the main written submission, and then the court. The registry internally decides on which annexes have to be translated. And if a party submits an annex in Spanish, for instance, it has to provide the court with an official translation in either French or English. And then eventually, if that document is really, really of paramount importance for the case, the court will produce a translation in the other language of the court. So it is
expensive. Yes.
It is expensive, yeah. It is expensive. Not for the parties, because it's
Well, they can change the rules and require the parties to submit them in 2 languages. But the second question is, I can't help but compare how the Inter-American Court functions in comparison. And of course, we have this barrier of exhaustion of domestic remedies. So I'm fascinated by the idea that you don't know what the case is about until very late in the proceedings. You look at the evolutive nature of the case, and it makes me think of the Legrand case, where in between you had the decision, the advisory opinion of the Inter-American Court, saying that the right to information about consular assistance is a human right, and that the Germans actually changed their oral pleadings and called it a human right on the basis of that opinion, and then the ICJ refused to touch the issue in its opinion. It refused to really answer the question, is it a human right or not, in the opinion of the court. And I'm wondering, when something kind of that stark, it's almost provocative for the court to take a position on it. for the court not to do so. Is that common in this interest of, I don't know, leaving some ambiguity or not taking positions?
I think one, of course, may be from time to time disappointed with the silences of the court. I think I try to explain the institutional reasons for those silences, because always the question will be, is that absolutely necessary at this stage to say that in order to give reasons for the result that we come up with? And if it's not absolutely necessary to use the language of human rights for the right to be assisted by the council, that might be disappointing. But the court is very much aware. If you read the Diallo case, the merits case on Diallo, the court is very much aware of the pronouncements of other courts and tribunals, and is, not to mention the Bosnian case and debates.
But if I could just do a follow-up on this, one issue, again, where the court has been less than crystal clear is the interrelationship between international human rights law and international humanitarian law. And for a human rights body to look for guidance to the ICJ, it's not helpful. You could say it's absolutely necessary that the ICJ set this out clearly, and it doesn't. So,
but it's not. I think today's composition of the court also does not push the court to have great doctrinal findings, and then one should complain to the states when they put up candidates. But I think also, and maybe this is a bit of an elaboration, but I also think in the academic world, advisory opinions of the court are usually seen as providing, and you mentioned articulation between human rights law and humanitarian law, in the Wall opinion probably. Advisory opinions are considered by professors as being a great way to develop international law and to have pronouncements on the development of international law. Well, I think that our profession is mistaken, because if the more the General Assembly is going to ask questions to the ICJ on quite contentious issues, Kosovo, the war, nuclear weapons, the more the General Assembly will put questions to the ICJ, the more states will be willing to control the composition of the court and appoint to the bench people who have some connection with themselves. If it's to settle the dispute between Burkina Faso and Mali, who cares? Really, any good professional can do it. But I think that I'm speaking as an academic, I'm not contesting the composition of the court. The court is what it is today. But there has been an evolution in the composition of the court. That is certain when you look at the background, the biography of the members of the court. And I think, I'm guessing, that I think states are very much aware of the fact that that the court must come up on those highly political questions with some results that they can find acceptable and hence control or indirectly control political. So that, and to go back on the question of development of the law, I think one has to keep that in mind.
Professor Murphy, you've been very patient.
Thanks. Pierre, thanks very much for coming. It's a real pleasure to have you here, particularly after the experience you've just had at the court. I wanted to return to the issue that Mike Matheson and John Crook raised, and maybe you're getting a little bit of pushback from those of us who are involved in the Iran platforms case. It's obviously disturbing to think that a major power appearing before the court, presenting arguments for why it believed it acted in self-defense, would perhaps have its evidence viewed as doubtful or uncertain, maybe a fabrication, maybe just a distortion, whatever. And I think that's a problem not just for the major power, but I think it's a problem for the court, too. The court, if it isn't going to engage in its own fact-finding, really has to rely on the evidence presented to it by the parties and should be taking that at face value unless it is on itself going to do something about it. So let me throw out a proposal and see what you think of this. What if the court formed a committee of 5 judges called the Evidence Committee? And the job of the Evidence Committee was, at the end of the written pleadings, usually after the rejoinder has been filed on the merits, this committee would sit down and go through each of the exhibits to determine whether or not there was some issue of concern to the court regarding accuracy, authenticity, ability of the court to interpret, a photograph, an image, for the purpose of, between the time of the end of the written pleadings and the time of the hearing, the court doing some of the things that Mike Matheson was suggesting. Appoint a special master, appoint a group of experts. You said, who has satellites? Well, actually, there's a lot of people now who are expert in satellite imagery. There's a lot of commercial applications. There are a lot of former government experts out there and other individuals out there. And you're right, the court doesn't have a list right now, but
it could.
It could.
Sure.
So what about that as a proposal? The idea would be not to slow down the proceedings, but to give the court, a firm opportunity and make it confront at an earlier stage whether there's some issue here, even if the full court hasn't digested everything. Maybe at least a group of judges could do so.
Thank you, sure. No, I think it's a very fine and good idea, and I think it's not only for that kind of dispute when one of the parties is controlling in a way or seen by the court as controlling most of the evidence, but for any dispute it would be great that the court in advance of the oral hearings would look at the evidence presented and try to make sense of it and eventually ask further explanations from the parties, etc. Because there are other ways than just setting up an expert, asking an expert opinion. Yeah, of course. Everything is possible. The fact of the matter is that the court has never done it. We can write and suggest that it would do it. The difficulty, as I see it, is that it would give those 5 judges some, because they would know the case better than their other colleagues, it would in a way break the equality between the judges, and some judges will be more informed than others in a way, or will be seen by their colleagues as being more informed, and that might create some tension. Or is that a permanent committee? Is that a specially elected committee composed for that case? Will they have to go through the evidence of all the cases? Will they be there in The Hague to look at it? No, it's a fine idea. The fact that since 1920, the only case, the Corfu Channel case, as we all know, is really an exception, and the fact that the court has never considered useful to do that is quite telling.
Yeah. If a follow-up question really goes to the culture of the court and how open it is to such innovation. And just in your time there, the procedures you've described to us, how long-standing are they? Are they evolving slowly, rapidly? Did you see kind of innovation underway or discussion of innovation?
No, the court is institutionally, I think, extremely conservative in the sense that things don't change quickly. and that change is not easily envisaged. There is a rules committee. It takes a lot of time for rules to change. Let me just. It really is not. One should not take it as a form of criticism or a way to criticize the court or to make fun of the court. But we are called in the registry to draft notes regarding the procedure, the rules of procedure, explaining to the judge when there's an incident, etc. Well, the natural tendency, or what is required of a good note of the registry explaining rules of the court, is to go back to the travaux préparatoires of 1920. Now, we all know that travaux préparatoires in the Vienna Convention is a secondary means of interpretation, and if the words are clear and allow for contemporary application and interpretation, but this is a little bit the culture of the place, and it might sound absolutely bizarre and weird, but the institutional reason for that is not sheer conservatism and simply bureaucratic habit, but it's treating equally cases that on certain points appear to be similar. That is, giving to the parties a consistent approach on procedural matters. If we've done that this way previously, why should we change now? If there are no paramount reasons to change, because we don't want to surprise, we don't want to now predictability in issues of proof is another matter.
HP, did you have a question? Yeah.
Thank you. My name is HP Scheidermacher from the Netherlands Embassy. I'd like you to elaborate a little more on the decision-making process. You said that during the oral arguments, most of the judges pretty much form their opinions, and then follows a lengthy drafting process. Is that drafting process used to, or do they ever change their positions during the drafting process, or do they use the drafting process to improve their own positions that they took in the first place?
Well, they never, when I said they took, I think they form their opinion largely. They come by themselves to form their opinion during the but it's not final, it's not explicit, it's never, they don't speak about it, and so it's during the writing of the note that they, I guess, and as we all know, it's when you have to write that you start to think, that is when they really start to articulate their views. But it's you know, what is writing, it's a constant, it's a process. So, and sometimes, I mean, when you look at the note, sometimes a judge very openly say, on this I don't have a clear view. I'm waiting to hear the views of my colleagues, and I'll form my opinion later on. Sometimes it's very frank. Sometimes maybe, we don't know. It's a kind of posture for this kind of negotiation. But I mean, you know, if you come out of the woods too early, too soon, too late, because it's this collective deliberation. So I think it really depends on one person to another person, and some judges have very, very strong views on the merits, on the issues. Some judges don't, and it really depends on case to case.
Okay. Last question, I think, and then we'll have some more informal conversation.
Hi, Bart Shefchik at GW Law School in WilmerHale. You mentioned the importance of oral advocacy before the court, but a lot of times it seems that the party's argument is simply read, and there's not much back and forth between the court and the parties, because the judges cannot ask any questions except for at the end they can submit written questions. And then I think at one point there was thought given to the ability of having the court ask questions during the proceedings. And of course, with a large court, you have the problem that, well, first of all, some judges aren't necessarily used to that tradition, and also if you have 15 judges, it can become a little bit chaotic. But I think there's a widespread perception that this would actually very much enhance the value of those oral proceedings and really hone down the dispute to what's really at stake. Do you know if there's has there been much progress on that debate, and has the Rules Committee given thought to changing those procedures in any way?
But the rules themselves state already that the parties should use the oral proceedings only in order really to underline the main points in dispute, and they should not. Now, the paradox is that the court sometimes gives too much time to the parties, and so the parties are free to dwell and at length on and to repeat and to elaborate. Now, on the very academic nature of the oral presentations of the parties, as you said, counsel read out a text. So I know that some judges find it utterly boring and they would prefer to ask questions, etc. I think there are probably two reasons for that. First, you have interpreters who translate immediately, and if you want your argument to be heard by all the court, you want the interpreters to follow you very precisely, and you want to submit to the interpreters your own draft in order to make sure that all the judges in their language that they use will have a clear view and idea of what you say. And that's why it is, 20 minutes reading or 1 hour reading of the paper. Second, I think, why is there so little intervention by the judges? Why don't the judge interrupt the parties, ask them, raise questions during the pleading, etc.? I think it's simply because sometimes you don't know what the parties finally will come up with. And as I said, I think the court, the proceedings by themselves are a moment during which it is possible that the parties come together on certain points. When you have a case on request for provisional measures, you have the request, and the defendant comes, you don't know what he's going to say. You absolutely don't know what the defendant is going to say. Take the Costa Rica-Nicaragua, the latest, not the river case, but the latest case on the mouth of the river dispute. Nobody had a clue of what Nicaragua would come up as arguments, because there was never a written. So you have to hear first what the state tells you. And it is what the state tells you that really forms the dispute and that creates the dispute. So intervening at that stage or raising up questions is quite uncomfortable for the judges. They raise questions at the very end. They discuss those questions, of course, before putting the questions to the parties. If a judge has an ID for a question, the red room next to the Great Hall of Justice, that's where the court meets before the hearings, and they discuss, and some judge will say to their colleague, well, let's wait, ask your questions at the very end of the proceedings, not now. Shall I do it after the first round? No, wait for the second round, etc. Why? Simply because it really is at the end that you know whether the question is still relevant or not. And there is this fantasy, this hope that the magic of the proceedings will reduce the dispute as much as possible. But it's not to be compared to any other court for that matter. That's true. European Court of Justice, you have 5 minutes to answer questions that they put to you, half an hour at most, and next case is there. And I guess US Supreme Court judges intervene a lot, and so it's a completely different culture.
All right. Well, thank you for giving some insights into that culture and allowing us to peek in the door, behind the door of the Peace Palace. Please join me in thanking Professor Judicial.